Hello, everyone. Welcome to today's program, Understanding the Role and Services of the Los Angeles County Child Support Services Department. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association. This program is presented by BHBA's Family Law Section, which is sponsored by White, Zuckerman, Warsawski, Luna Hunt LLP, Lawyers Mutual Insurance Company, SoberLink, and Our Family Wizard. White Zuckerman provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. And you can learn more about them at wzwlh.com. SoberLink provides objective, real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. SoberLink's trusted alcohol monitoring system has an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, and real-time results and customized testing. You can learn more at soberlink.com. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers. Learn more at lawyersmutual.com. And Our Family Wizard is a co-parenting platform designed to help families communicate more effectively, reduce conflict, and create reliable court-admissible records. Features like tone meter AI, shared calendars, expense tracking, and in-app audio and video calling help support compliance and better outcomes for families navigating custody matters. And now I am delighted to introduce our speakers for today's program, Maria Ferguson and Scott Spotter. Maria is a supervising attorney at the Los Angeles County Child Support Services Department, where she has dedicated over 25 years to child support law and administration, handling complex interstate and international cases. A policy leader and advocate, she co-chairs legislative work groups shaping child support policy at the state and county levels, serves on the Los Angeles County Management Council Special Services Committee, and champions women's leadership through initiatives such as the Women and Girls Initiative Project and LA County's Women's Leadership Conference. Scott is a staff attorney at Los Angeles County Child Support Services Department, where he has dedicated over a decade to child support law and administration. After graduating UC Berkeley School of Law and before joining the department, Scott enjoyed a lengthy career in private practice, handling various family law matters. Scott is a legal history buff and enjoys spending time with his Maltipoos. And now I'm delighted to hand over the program to them and take it away.
Good morning, everyone, and thank you to the Beverly Hills Bar Association for having us. Again, my name is Maria Ferguson, and Phil and I, together, we oversee some of the legal cases and teams at Los Angeles County Child Support Services Department, or as we'll be calling it about 200 times today in the next hour, CSSD. Before we dive in, here's our mission in one sentence, and it's actually a good one: connecting with parents and caregivers to provide child support services. Our core purpose is simple: to ensure children thrive. Everything we're about to walk you through, every acronym, every code section comes back to that one idea. We know an hour of MCLE material can feel like a lot, so we tried to make this practical, things that you can actually use the next time a client walks into your office with a child support question. And yes, there will be acronyms, lots of them. So if we start getting carried away and it starts sounding like a monologue, please stop us, ask. Phil and I have been with the department since 2001, and we probably even been using obsolete acronyms even for our newer internal team members. Let me see what they are. So who is CSSD? Who are we exactly? Los Angeles County's Child Support Services Department assists parents and legal guardians by establishing parentage and obtaining and enforcing financial and medical support orders for children. We're a big operation, over 1,200 employees spread across 7 offices throughout the county, including roughly 80 attorneys. There used to be, when I started, there were probably 125 of us. So if you've ever wondered why there always seems to be a CSSD attorney in the hallway at Stanley Moss, that's why. We are everywhere. Here's the piece we want you to really absorb because it comes up constantly. CSSD represents only the County of LA. We don't represent either party and we don't represent the child. We're not your client's lawyer and we're not the other side's lawyer either. We're here to help everyone navigate the child support system and the court process, but our client really is the County of LA. Next slide, please. What does CSSD do? Let's talk about our actual job description. CSSD locates parents, establishes legal parentage, and establishes new orders for both financial and medical support for the children. We enforce new and existing child support orders, and this one surprises people. We can enforce current spousal support also, but only if it qualifies alongside a child support order. We also modify child support orders and we enforce and collect arrears for both child and spousal support. Think of us as an agency for anything with a dollar sign attached to a child support, establishing it, enforcing it, collecting it, and adjusting it. Next slide, please. What does CSSD not do? Equally important, maybe more important, is what CSSD does not do, because this is where we get the most confused phone calls and occasionally a process server showing up in the wrong building. We don't handle custody or visitation issues. We don't accept services or documents related to custody, visitation, or any pending litigation on those issues. We don't handle divorce or legal separation. And again, we don't accept service on those either. Sometimes we'll get someone to try to serve us because we're enforcing a child support order for the parties. And then another party or an opposing counsel does not know where to serve the other party, and they'll try to kind of sneak it in through us. We can't technically do that, but we also do not establish or modify child support orders on our own. Remember, spousal support only comes along for the ride when it's tied to your child support case that we're already handling. And we don't obtain, serve, or enforce domestic violence restraining orders. So if a client's issue is purely custody, divorce, or a DV restraining order with nothing else attached, that's not us. We can send them to family court or the self-help center and not our office. But we are now at Stanley Mosque, and we'll talk about that a little bit towards the end. Next slide, please. Let's zoom out to the state level for a moment. DCSS, the California Department of Child Support Services, is the state agency created under Family Code Section 17200. DCSS is designated to administer Title 40 state plan for securing child and spousal support, medical support, and determining paternity per Family Code Section 17202. Think of DCSS as the state umbrella, and think of us, CSSD, as one very large branch underneath it. Slide. To coordinate delivery of services statewide, each county or group of counties has local child support agency and an LCSA dedicated solely to handling child support in that area. That is under Family Code Section 17304. CSSD is the LCSA for the County of Los Angeles. So when you hear LCSA in our world, that just means us. Slide. When does CSSD open a case? There are two main ways. The first one is when a participant applies for our services directly. So if you guys are handling a case, you are always welcome to send your your client to one of our offices or even go online. The second, upon a referral from DPSS, that's the Department of Public Social Services. That's when a participant is receiving a needs-based cash grant, commonly known as CalWORKs. Let's say a parent is receiving that aid. A child support case with us essentially comes with that. Slide. This slide is here as a visual reference for the application process itself. The point to make out loud is simply that applying is very straightforward, and our office and website both walk applicants through the intake steps. We'll provide that slide to everyone. I think you guys will get this packet, actually. The good news for most people, CSSD services are free. But there is one exception worth remembering. If at least $500 was disbursed to a non-welfare case in the prior federal fiscal year, a $35 annual service fee gets deducted from the first payment received that year. So it's not really a fee for using us. It's a small federally required fee triggered once a certain amount has already moved through the system. Slide. This is section header. We're now moving from what CSSD is into a more practical nuts and bolts side, how you actually set up a case once an order already exists. Slide, please. So all payments must be made and processed through the California State Disbursement Unit, the SDU, not to us directly, not to the other parent directly. Everything routes through the State Disbursement Unit, which we call SDU. So when you call and we say, send it to SDU, that's what it is. Here's a practical tip for your practice. You can expedite enforcement by providing copies of all court orders and making sure that the orders are already payable to the SDU at this address right here, PO Box 989067. So again, you'll get a copy of this. So if you just make it a practice to have the court order the obligor to make the payments through this, it'll be so much quicker for us also. And one more detail for your clients, as of February 25, 2021, credit and debit card payments made online or by phone to SDU carry a 1.9% service fee. And that's paid to the card processor, not to us. Site. So here's a nice one for the budget-conscious client. Generally, participants are not required to pay fees to file pleadings or documents on parentage or support issues in a case where Title 4D agency, that's us, is providing services under Family Code Section 17400. Slide, please. Oh, I think there. Let's talk logistics, because knowing the building layout will save you real time. The 4D courtrooms, departments 245, 409, 417, 518, and 548 are all located now at the Stanley Moss Courthouse on Hill Street. CSSD maintains a small court operations office on the 6th floor, and we will accept service of documents related to 4D child support cases there. A quick caveat, though, we do not accept service there for separate lawsuits where CSSD or the county is a named defendant. That's a different mailbox entirely. The court's 4D filing window, the Domestic Support Unit or DSU, is on the 4th floor, room 425B. That's right across the hall from the Family Law Clerk and Self-Help Center. I'm sure most are familiar with that. So 4th floor to file, 6th floor to serve us. That's probably worth writing down. Next slide, please. All 40 cases are heard in our courts. So once a case is open with CSSD, generally all litigation regarding child support has to be heard in the appropriate 40 courtroom. If something is mistakenly filed outside the 40 court, family court is supposed to transfer that child support issue over to the correct 40 courtroom, unless exceptional circumstances exist. That standard comes from Local Rule 5.24. So the practical translation, if your client has a CSSD case, don't file the support motion in a random family law department and then hope for the best. It is going to end up in a 40 court anyway. So save yourself the transfer paperwork. We will file a request for it to be transferred to us, and the family courts will always transfer it to us anyway. Thank you. A few housekeeping rules before anyone sets foot in a courtroom. All filed documents must be timely served on CSSD, and if both parents are parties to the action and 4D services are being provided, CSSD will actually, we'll forward the non-moving party we won't serve technically, but we will forward the pleadings to the non-moving party related to the support. All the documents related to the support. CSSD will notify both parties anyway of the date and time for a mandatory meet and confer. We always do that, probably 2 weeks before the court date. And if there's a conflict with that call, please call us to reschedule as soon as possible. We try to arrange for someone to appear from one of our staff members, one of our staff attorneys. It's not guaranteed. We don't make promises to move it, but we can also appear remotely. Slide, please. Both parties are required to provide fully completed income and expense declarations, or that's a Form FL-150, as most of you know, with all attachments per Local Rule 5.9. And incomplete FL-150s are one of the most common speed bumps that we see. The meet and confer letter from CSSD sends all of the, it actually explains exactly how to submit those financial documents in advance. So encourage your clients to actually read that letter. Because many of our case participants are not represented, it is an easy read. It gives them the list of everything that they need to file before the court date. And there is a number there that they can also call. So don't tell them to not just skim it and toss it in the drawer like most of us do. Slide, please. The purpose of the meet and confer is to discuss the case and make a good faith attempt to settle all the issues. And we actually were very instrumental in trying to get the parties to maybe stipulate before the court date. If the parties are agreeable, one of our attorneys will prepare any proposed stipulations. On the numbers side, once recertified, CSSD in the 40 courts must use the DCSS guideline calculator. Right now, CSSD in the courts are actually using XSpouse. The DCSS calculator is technically accessible to the public on the DCSS website. But that same website confirms the calculator right now is currently decertified. So yes, it exists, and no, it's not one being used in court today. A little bureaucratic irony for you, but we are, I believe it's Philip might know better. I believe it's coming out sometime in September. Site,
We
please.
hope.
We have. They've been telling us since I think February. Thank you. So the 4D courts now use LA Court Connect as well, or LACC, and that is the good part. You no longer need a separate formal request just to appear remotely, even in our 4D courts. So you simply check in online the day of the hearing at mylacourt.org/LACC welcome. There's even a video tutorial available if you want to walk through it once before you're relying on it live. We send the address and a link to usually to our case participants. I'll flag that link on these resource slides coming up later. And now I will hand it over to my friend Scott.
Thank you,
Philip,
Maria.
thank you.
Thank you to all 69 people I see has jumped online with us. So this rule came down from the feds. It's called the Flexibility, Efficiency, and Modernization Final Rule for Child Support Programs, FEM, and that was in 2016. It required states to enact laws and regulations to improve the efficiency of the child support program. Now, in our state here, the legislature enacted it as Senate Bill 343, and that only took a short 8 and 10 years to enact. Next slide, please. Now, the big ones, it made changes to two areas, and that was the guideline calculation, and that's as of September 1st, 2024. And it made a formula change where it updated the K factor bands. That's the portion of each party's income allocated for support. Due to the magic of an ex-spouse, you don't need to know much more about that, except your high net worth clients are going to be paying more. Your low income clients will be paying less than prior to September 1st, 24. We don't have a time machine, so we are kind of stuck with that now. The low income adjustment is now tied to the full-time minimum wage, so that'll be more cases than prior. There's new deviation reasons for low income adjustments. It's adds severance pay, your veterans benefits, and military allowances. Now, probably one of the biggest change, there's a proration allocation has gone from what was the equal splits for add-ons, that's your child care and unreimbursed healthcare expenses, to now based on net incomes. It's also an option for an obligee to collect child care through itemization rather than an amount certain each month. If you've ever spent any time in our courtrooms, you'll see parties fight ad nauseum over those cash daycare payments to family members. So we were hoping this might lighten the load on that a little. We're still seeing if that will happen. Next slide, please. Now, the other big change is how we establish our cases. That's in filing our summons and complaints and petitions. And that's of January 1st of this year. You ever dealt with this in the past? If we didn't know something about somebody, we always filed our petition based on a presumed income, which was the minimum wage. Now, if we don't know that, we have to investigate and consider 14 earning capacity factors, then plead income based on that earning capacity. Default judgments without a hearing are only possible if the summons and complaint is based on actual earnings. Before this, the majority of our cases went through default. All earning capacity cases now must be heard by a notice motion. If there's additional annual modification reviews required for these default judgments based on that earning capacity, that's when income is unknown. If we know your income, we don't have to go through this, and that's going to be all your W-2 employees, any income provided to the Employment Development Department, we have access to that. And now there's some expanded set-aside provisions if you get a client coming to you saying there's been a default judgment, you have a little more leeway to try to get those vacated. Next slide, please. is probably our what we do best, enforcement remedies. We have certain remedies available to us to enforce judgments that may not be available to you when you represent a client. Uh, Quickly, we can levy people's bank accounts. We can file a proof of the claim in a bankruptcy. We have the civil contempt statutes open to us against both obligors and employers. We have a debt reduction program where you can compromise monies owed. The income withholding orders, which we're quite good at. Intercepting federal and state income tax refunds. When parties live out of state or out of the country, those are intergovernmental and international cases. Liens, we can do against your civil lawsuits, against properties owned, workers' compensation lawsuits. Suspending licenses, we'll talk a little more about that in a second. A big one, we can suspend passports. In fact, we have to. In the probate realm, we can come in as a creditor on trust and wills, qualified domestic relations orders, quadros, but only for child support, not for community property interests, and writs of execution. Let's go a little deeper into those enforcement remedies now. We call it the financial institutional orders withhold. These are your bank accounts. And even if they're paying, we can dip into those. There is an exemption if the obligor is in compliance with their court-ordered arrears payment. That's only up to $3,500 though. And then they have to be paying that child support and arrears by wage assignment or 50% of their earnings towards support. If you get a client come to you with that, you can file a claim of exemption. We then can go into court to file a motion to oppose that. But if you get somebody coming to you, always call us. That's the first and best way to try to deal with these. Next screen, please. Now, this is what we call the debt reduction program. Now, these are although only arrears owed to the state. That's if the party was receiving public assistance, welfare. If you get one of these clients coming to you, there's an application you can help them fill out and file with us. Usually we'll have you make an offer. Oftentimes it's pennies on the dollar. It's an administrative review, not a judicial review. And there's no minimum arrears balance needed. But again, it all has to be owed to the state. If they are owed to a party, we cannot go through this program for that. There also can be no pending legal actions. Those are your civil lawsuits, workers' compensation lawsuits. And if your client has assets over $3,500, that excess will be added into the calculation. And like most bureaucratic processes, they can take up to 60 business days, so it's not a quick process. Next, please. Your income withholding orders, wage assignments. Again, one of our strengths, whenever an order is issued, the court has to order one of these earnings assignments orders. And that's per federal law and Family Code 5230. We do not need to go back into court to get one of these. It's administratively issued. And to anybody who's considered an employer, and that employer must begin deducting support within 10 days of service. And these take priority over all your other earning withholding orders, except for the tax people, your IRS tax levies, unless we got to you first prior to the tax people. There is a cap at it, though. We can't take more than 50% of disposable net income. That may be a Consumer Credit Protection Act violation. If we do, we don't want to get holed up with that. Again, something we can do. Next screen, please. And this is a big one. We can intercept tax refunds. We are authorized and will automatically intercept those federal and state income tax refunds if past due support is owed. All this stuff is automated. That thing gets shot out every October if somebody owes those. Now, sometimes if somebody's contesting that tax refund could be placed on a hold by our state counterparts. At the local level, we have no control over that or when it can be released to the obligor. So now these are what we call intergovernmental. That's when one party is out of state. We can establish an order via uniform support petition. Now we have a lot of law students with us in the summer. This is the international shoe. If you remember that from way back when in law school, they love seeing this in action, everybody's favorite case. We can register another state's court order. We can modify another state's court order. That's if California has continuing exclusive jurisdiction. There's lots of appellate opinions on that one. So that's not as simple as one might think. We can enforce another state's order, though, with or without registration here in California. That's UIFSA. Remember that going back to January 1, 2016. And full faith and credit for Child Support Orders Act. Next screen, please. We're also under the Hague Convention. We can establish and or enforce support if the other country, though, they have to be a signatory to the 2007 Hague Convention on the international recovery of child support and other forms of family maintenance. That other country has to be a foreign reciprocating country. Then it would be treated the same as another state in the US. And if you remember this term, we need comity. Next screen, please. License suspensions. Now, there's been a big change in this area of the law. If you used to deal with this in the past, we suspended a lot of driver's licenses. The law has changed on that as of January 1st, 2025. We can only suspend a driver's license now if we can show the obligor earns at least 70% of the area median income. Now for Los Angeles County, that's 87,760. 70% of that is 61,432. So this is only going to be your self-employed obligors that we can prove they're earning that much. If they're a W-2 employee earning that much, we'll be garnishing their wages. They won't fall into this bucket. Now, we can still do all your other kinds of occupational licenses, as your business licenses, our bar cards, your doctor's licenses, contractors, that's a big one, teaching license, cosmetology, real estate. If you like fishing, your fish and wildlife licenses, and a lot of security guards. We do those quite a bit. If you get a client with us, call us again, and we'll do an administrative review. If you're unable to come to an administrative agreement with us, you always have the courts open to you. Generally, if somebody makes a good faith payment, you're getting close there. Something, again, we do quite well is we can file liens. The California Insurance Intercept Program, those are your personal injury suits, your civil lawsuits. We can intercept insurance settlements. We can get up to 100% of somebody's settlement to reach how much they owe. Oftentimes what happens is an applicant's attorney or petitioner's attorney will call us. We're willing to negotiate. We want somebody to get a little piece of their settlements for going through. It's hopefully not too bad of an injury. We also can do on your civil lawsuits, your contract actions, all those types of things. The real property liens we're quite good at. We just file that abstract of judgment in whichever county somebody might own property. Then if they try to do something, sell, refinance, then your title search should turn that up. Again, call us, we can work something out. Workers' compensation, lots of people get injured on the job. We will come in there as a creditor. We can get a portion of that. Next screen, please. A very effective enforcement remedy, the passport denial program. And this is up at the federal level. It requires us to submit to them anybody who owes over $2,500 in arrears. If they get that name, federal law requires them to not give them their passport and deny that. And at our state level, the superior courts do not have jurisdiction to even make an order on that. We have our office, the state level office has very little discretion on that. State courts have none. If you remember your separation of powers, and that's the California Constitution, Article 3. Remember your common law classes. Judiciary cannot prevent the executive from enforcing the law unless the law is unconstitutional. And that law has been upheld through a couple of appellate opinions. If this is going to happen, next screen, please. A warning notice, it's sent annually to all obligors with delinquent child support obligations. It'll advise them if the arrears are owed, they're going to be submitted to this program about their passport. They have the right to request administrative review within 90 days of this. Now, it's very strict to get these things released. It can only be released if the child support arrears are paid in full, or an administrative review finds that the arrears balance was not in excess of $2,500 at any time during which the certified arrears were submitted to the federal people, or the obligor meets one of 3 federal emergency release criterias, and that's usually an emergency in another country or a death or imminent death of a close relative. Next screen, please. This is a stipulation for a waiver of arrears. The Judicial Council, they do have a nice form, FL 626, although unlike in your family law cases in your home court, parties must file a request for order to have a stipulation for waiver. And this is, again, only the what we call the non-welfare arrears approved by the court. Both parties have to be there so the judge can make sure it's a knowing and voluntary agreement. If they're not coming to you, there's a free help service. The facilitator can help them. Now, they want to contact us to confirm the arrears amount due and owing before even going down this lane, because any terms for the waiver must be clear and enforceable by us. And that payment also has to go through the state disbursement units. If somebody has multiple cases with us, though, those payments are going to get allocated for the federal requirements, which that a payment cannot be directed to only one case if an obligor has more than one case. If they like one obligee more than the other, tough. Obligor should consider all your cases before entering into these agreements. And actually, I was going to, on these, be very careful with these as a family law practitioner. A case came down in February of this year, Marriage of Allen, 118 Calap 5th 476, where they said somebody can unwind one of these agreements unless the magic words, there's a bona fide dispute as to what is owed. If you are going to represent somebody on one of those, do yourself a favor, make sure it's very clear there's a bona fide dispute as to the arrears owed. Next screen, please. Pass through of assigned arrears, those are the arrears that are owed to the government. And this is a fairly big change. This says May of 24. Any amount of support collected in a month in payment of an assigned support obligation shall be passed through now to a former recipient of aid. And if it can't be delivered to that obligee within 6 months, fortunately cannot go back to the obligor. It's sent to recoupment, the state. That obligee still has 12 months to make a claim to get it out of that recoupment bucket. And unfortunately, an obligee cannot waive these arrears or close the case, as in theory, the debt is still owed to the county for welfare reimbursement. But your obligor can still file for our debt reduction program and try to take care of that administratively. So the screen, it's very important to your practitioner. These are the numbers to get directly to us. If you call our customer contact center, you're going to wait quite a long time. And that customer contact center really is just for your unrepresented parties. So we have numbers to each of our offices. Again, save those. It'll get you directly to our secretary, but it's going to cut a lot of time out of waiting. And if you're going to give us ex parte notice, that's the place to do it. We have some useful resources. There's our website. There's the state website. There's your federal website. If you don't want to pay for the license for ex-spouse, that's that free guideline calculator. Now, the only problem is this, it cannot calculate only spousal support. So if you have any type of a practice and you get clients that need spousal support only, this one may not be the free program for you. And like Maria said, it's out of compliance now, not our fault. Someone at the state level did not update it with the old President Trump's big, beautiful bill with the new tax tables. The state disbursement unit, as you know, all wage garnishment payments are supposed to go through here. That's up through the West Sacramento. If anybody's ever sending any money up there, make sure you put a case number on that. You don't want it going to the wrong case. If you have you want to get out of private practice, maybe tired of clients calling you at midnight, or you have a young associate there, you can apply to us. We hire attorneys a couple a year. Before we get to the next one's questions, the last screen's a QR code. If you have one of your clients scan that, someone in our office is going to get back to them within 48 hours. So if they can't pay you anymore, give them that QR code. And with that, I think I saw some questions in the chat. We have a couple minutes. Maria and I can plow through a couple of those.
Yeah, I think I did see the question on. I think was it posted on the chat? Oh, there it is. Let's see here.
All right, so the question that was requested earlier within the chat, if a parent is judgment proof and failing to support their child, can you get a running judgment or deficit accumulated against them for failure to pay support? Do you need a court order to seek this? Let's see. Context, I represent some kids in a guardianship with grandma who are not receiving child support from either parent. However, there's currently no court order in place for support. Should I seek an order, or is it assumed that all parents should support their children and all grandma needs to do is file with child support services?
If she has the guardianship, she can open a case with us.
Yeah, she can come into any of our offices, apply for it. She does not need a pre-existing support order. Just come in, fill out the application. The caveat is you said something about judgment proof. So I'm also assuming that maybe the obligor or the non-custodial parent in this case may not have income available. We're going to have to look into that. But yeah, we'll open a case and try to establish a court order against this obligor.
Is anybody ever really judgment proof? That's where the skill as attorneys come in to see what we can do about that.
Right. And if there is an existing court order, we will register that order and it does accumulate. Even if that person appears to be judgment proof at this time. Like Phil said, these days, who is actually judgment proof?
All right, so we have another question in the Q&A from Matthew. Can you take us through chronology and procedure of a case where paternity is not yet established? I believe the statute refers to a putative parent. Can a support obligation be established before paternity under the statute? Alternatively, must a putative parent provide financial information prior to being conclusively determined a parent?
We will have to establish paternity before we can move on to the money parts of a case. Now, it could be a genetic test, a voluntary declaration of parentage, a putative parent. There's 7611D parents if somebody's held themselves out to be a parent. So there's a few ways to go about it. We've even had cases where there's a multiple parents.
Mhm. Correct.
And we pay for the genetic test if somebody wants one and legally is can get one. We're pretty good at that. We have a contract with LabCorp.
Unless
All right.
there's a presumption, we usually offer the genetic test.
And I have another question here. When an obligee client qualifies for CSSD services, when would you recommend that they go with CSSD versus filing their own support motion in family law court with a family law attorney? What factors should the attorney consider when deciding whether to take on the client's case versus referring them to CSSD?
If you feel you need a forensic, and you have the money to hire a forensic accountant, uh, our office will never pay for a forensic, so that might be a time. Self-employed obligors may not be our strong suits. We don't necessarily have the time to kind of trace monies in and out of bank accounts or LLCs or C corps and S corps. We don't
But
take.
once you have the proof, we do have the ability to do all those calculations. If there is already an existing order, the easiest and the most effective services that we have is enforcement and establishment of parentage. Now, investigating where monies are or someone's assets, that's probably where you come in, or proving that a self-employed individual has assets and it's hidden somewhere. That's probably not our strongest suit because we just don't have the resources to do the investigation or, like Phil said, hire a forensic accountant to do that work.
Or nor do we have the money to depose somebody if you think a deposition might elicit good evidence. Yeah, we don't defend them, nor would our office let them take them.
As much as we'd love to.
As fun as those are.
I have a second question from Matthew. Second question. Assume one parent starts a case with you and then the parties want to stipulate and no longer use CSSD. Can they step out once a case has started with you? Must CSSD or the court hearing that case approve?
As long as somebody's not on public assistance, they can close it out with us at any time. No objection from us.
All right, so it looks like we have a clarification question, perhaps.
And
Also,
the thing to remember, if I could just interject and remind everyone, we do not advocate for one party or the other. Our services is really to help everyone out and explain the process and help the court with establishing paternity and child support.
We don't have an attorney-client relationship with either party, so our role's a little different than if someone retains one of you to represent them. The advocacy is a little different. Now we want accurate orders, and sometimes it may feel a little different than non-representation, but statutorily we don't have that relationship.
all right, I have another question here. Also, to be clear, you were saying that an FL 626 waiver is not enforceable unless there is a bona fide dispute as to the amount. Can you repeat the case? Thank you.
You could give
1
us
second.
just a second.
It's a marriage of Allen, ALEEN, 118 Cal App 5th 476.
Let's see, then I have another question here. If an international person is not receiving her support from an LA resident, do they just call the main public number or is there another number that they should call?
It's the same number, our customer service hotline. I believe it's in one of the slides here. They will direct you to our intergovernmental division. The second to the last line right there. However, it is also in our website, on our website.
All right, and another question. Thank you for today. Question: is there an agreement repayment of arrears over 2,500? Can a passport be reissued if it was previously revoked?
Well, they have to get that amount down below that.
To zero, actually.
Yeah.
Once it's been reported, it has to be paid in full.
All right, and then I have another question here. All right, so it's more of a follow-up to the first question that they had originally asked. I've seen letters come to putative parents that say, among other things, boxes checked, we have been asked to open a support case. Law requires us to determine parentage, and then case number. Then it goes on to say, enclosed is an INE. Please fill it out and return it. So they do not have to return the financial information until and unless parentage is established, despite what the letter says.
That's
That's
it's really to file a petition with an accurate proposed support calculation, but yeah, if they don't, then the case still winds down its road.
yeah. If they want an accurate order, because see, we handle it's a volume. We handle so many cases, we can't necessarily monitor those cases. So if they want an accurate order, if your client wants an accurate order, someone just needs to reach out. It's better to communicate with us. Again, we don't represent either party, so your communication with us is very essential. It's essential. We can stop the process if someone is actually participating. So just because you submitted those forms doesn't mean we're going to file something against you. Submit it. And if we have a stipulation, that's actually also better for us. But yes, the short answer to that is, of course, you don't have to fill it out and submit it until we have established paternity.
All right, I'm just going to go ahead and try to gather some stuff here real quick. It looks like we do have some questions. Let's see. Are there situations where CSSD will proactively agree that a modification is appropriate before litigation when information helps facilitate that?
Either party on a case can request us to review to put a request for order on calendar. Once that thing's filed, certainly we can come to an agreement if we get both parties to collaborate. You know, or if parties want to agree to something prior to the filing of a motion or request for order, we can certainly do that also. I don't know how you get your fees then, but we could do it.
Right. And the thing to remember is certainly if the the obligor can ask us to review their case for or if the custodial parent can ask us to review their case for modification, the obligor can do the same. So neither party can call us and say, you did this. We are a neutral party. We are a neutral agency. And we get a lot of calls that accuse us of siding with one or the other. We just have to file it. If someone says we have proof, we're just going to have to take their word for it. Most of the time, there is a change of circumstance. By just a couple of dollars, we have to file. We are obligated to file. But we certainly do not touch a case that's been in litigation just 3 months ago. So if your client is adamant about filing a modification and we refuse to file it, you can file it anytime. They are welcome to file a modification. And
The
if
other
it's a
thing,
4B case, they don't have to file the fee
yeah, if
or
if
pay the fee.
somebody comes to us with that, they're getting in line behind the 1,000 other people that are requesting it. So if they if they want to get in court quickly, uh, you're probably their better option.
All right, let's see. What are the most frequent service mistakes that delay hearings in IVD cases, and how can attorneys avoid them?
I'm sorry, I don't think did you get that, Phil? I didn't.
Was the
Could you
question?
repeat?
Yeah,
Yeah.
Yeah, let's see. Uh, yes. What are the most common procedural issues that arise when an existing family law case is transferred into an IVD
oh,
courtroom, or what are the most frequent services mistakes that delay hearings?
yeah. If you
Probably that some of the other issues are filed in our courtroom, or that a child support services case is filed in a family law courtroom. It's going to be transferred back if you file it with other issues in a court branch. They will kick it back to us
yeah,
always.
the home courts have gotten very, very good at bifurcating out the child support and kicking it over to mosque, one of our courtrooms. Very good at that.
All right, looks like we have another one in the Q&A box here. Thank you for this talk. If, as a party's former custody attorney, if we call you to give you judgments, etc., is this an appropriate call, or should the now unrepresented litigant just call the main line?
I'd probably say to inculcate yourself from any ethical issues if you're not representing them anymore. You may not want to be doing things on their behalf, but it's up to you.
And it looks like we just have one last question. Do you ever act as a median?
Yes, all the time.
All
Only
righty.
on the
So
support issues, though. Not your custody and visitation or community property issues.
all right. Well, that looks like that's it for questions in the box here. Do you, either of you have any last closing remarks that you'd like to make?
No, but please call if you have any questions. Send your clients if they need our services. And if anyone wants to consider a career with us, I think we included that as well.
Yeah. I didn't know if we
Come
could do it.
over.
We got you to within 1 minute of your full hour of credits. It's not always easy to do. They were very good questions. I can't see who's on the watching us, but I'm sure we know many of you and very much enjoy working
And
with you.
thank you for having us. Yeah.
All righty. This concludes today's presentation. Thank you so much, Scott and Maria, for an excellent presentation today. And thank you so much to our audience for joining us. Have a great day, everybody.
Have a good
Thank you.
one, guys.